But we're here talking about utilities and the kinds of things that you can do if you've got a situation where your tenant simply isn't isn't paying the utilities, but those utilities are in your name, and every single month that bill is going higher and higher and higher. Um, uh, you're late for the sermon. We can't hear you. Yeah, well, I hope that's changed. Yes, I see that. It's better now. Yeah, I simply didn't press the button on my microphone. Rookie mistake right here. And so I apologize about that, but definitely I'm here and I'm going to start, answering your questions and talking about today's topic. But for those of you who have questions, the chat is an excellent way for those questions to get to me. I definitely want to be able to communicate with you and make sure that your questions get my attention. But for those of you who ask ahead of time, whether you're a member of our mailing list or whether you are a member of our Facebook group, Texas Landlords, you can get ahead of it, ask your questions ahead of time. I'll print them out and review them and be ready to answer them for everybody during the live. So let's go ahead and move forward then. With today's topic, because we want to know what kinds of things are available to landlords when you've got utilities in your name and the tenant isn't paying. So I'm going to tell you the things that I tend to suggest to landlords when they're in this situation, and also the kinds of things that I suggest to landlords in order to prevent issues like this from ever really coming into play. And so the first thing that I want to talk about is, if you don't have to, don't do it this way. Now, I recognize that in certain jurisdictions, you're required to do this. Again, that's not most places. And certainly in certain setups, you can't change this because you would need an entire new meter. So let's say, for example, you've got a duplex that's set up and there's only one meter. And so you got one meter that feeds both duplexes. You live in one and you've got a tenant living in the other. It's just not going to be possible with a single meter to split that up. And so you got to come up with a way to have a tenant, but when utilities are in your name. But if you can prevent this in any way, then certainly you want to prevent it. Additionally, if you've got one meter on duplex and you've got two different tenants, there's no way you can simply put the utilities in the name of one, because you could have that other tenant take advantage of the one tenant. And so one way that you could deal with that is to actually pay for the utility company to simply divide that utility access into two separate meters. And that way you can have your tenants sign up for their own. And certainly if you're renting a single family home, you don't have to keep the utilities in your name. You can make sure that your lease requires that all utilities be in the name of the tenant, which is always the better way to do it if you can. Again, in some situations, that's just not possible. But if you can have the tenant put the utilities in their name, that's definitely best. And so if you're going to be renting to tenants, disconnect those utilities before you hand over those keys. If you can put the utilities in the name of the tenant and the lease requires that they take full responsibility, don't trust them to keep the utilities in your name, and when they get around to it, switch it over to theirs. That's a recipe for disaster. If you can help it, and you always can in these situations, when you're handing over the keys and giving them access to the unit, make sure you've already disconnected all the utilities, because you don't have to supply a unit to your tenants with the AC already blowing and the water and the gas flowing. You can disconnect everything the morning of, hand over keys, and they can that day set everything up on their own, especially if you let them know that's the case. Hey, I'm going to be handing over the keys and handing over a unit with no electricity, no water, no gas, no internet. You're going to set all of that up. And moving forward, all the utilities will be in your name and I'll have nothing to do with it. That's the safest way to keep you protected from any kind of, non-payment issue when, the utilities are in your name and now you're kind of stuck having to deal with these utility bills. So you've got a situation where you can prevent it, and that's great, but you can't always prevent it. So if you've got a situation where you must keep the utilities in your name, then make sure your lease has very clearly stated rules about the utilities and about payment and about how the utility bill is broken up. So for example, we talked about the duplex where you got 1 meter and 2 units. Well, if you can't possibly tell how many kilowatts any one tenant is using, one thing you can do is let them know, look, this is split down the middle. Each unit is exactly the same, size. And so whatever the bill comes in, you tenants agree, half of it is yours and half of it is theirs. Unless, one unit remains completely unoccupied. And then you can say, well, for the time being, 100% of the use is obviously yours. This will go unused. And so the lease should bear that out. And it should be very clear in your lease if you're going to split it up between, 2 users, or if you've got some other configuration where, for example, you've got 4 units connected to a single meter. And now you got to say, well, you're going to get 25% and 25%, 25% and 25%. But however the usage is divided between the tenants, it should be clearly stated so that you can point to the lease and then point to the bill and say, your portion is X because you agreed to that in the lease and it is fair. Right? Or maybe you've got a setup where you've got what was once a quadruplex, but 2 of the units were combined into one big unit. You've got 3 tenants, but one of those tenants is occupying twice as much space. They should probably have twice as much responsibility for those utilities if they're all on a single meter. But if you're not making that explicit in your lease, it's going to be difficult for you to enforce that rule. So how do you make your rules enforceable? You make them explicit and you make them clear in your lease. Now, let's say you have explicit rules, and let's say you've got a good understanding as to how things are supposed to run, and the tenant simply violates those rules and doesn't pay their share. What can you do? Well, I'll tell you one thing you definitely can't do is shut off their utilities. And then I've seen this happen in all sorts of ways. Most of it is terrible. Now, I want to preface this by saying it is possible for you to have set up things in your lease where you technically can shut off utilities for non-payment. I don't recommend it because unless you're top tier and you know exactly what you're doing, you're probably going to get it wrong and you're probably going to subject yourself to all sorts of legal penalties. Generally speaking, a landlord does not have the authority to shut off the utilities of a non-paying tenant. And so I don't recommend that even if you wrote it in the lease that way, you don't pay your utilities, I get to go and cut everything off. I can pull the plug. I wouldn't recommend you doing that even if you put it in your lease, if you don't know what the law says and you don't know the consequences of such an act. Otherwise, stay away from that. Don't do it. Don't shut off utilities. Well, Ernie, I didn't technically shut off the utilities. They weren't paying me. The utility was in my name, and the utility company came and shut it off. Well, guess what? Between you and the utility company, you were the one with the obligation to pay, and so that constitutes you shutting off the utilities. So just because somebody else does it, if it's because you didn't pay the bill that you were obligated to pay, that's not a good enough excuse. And essentially, you're the one who's going to be hit with any kind of civil claim for an illegal electricity or gas or water shutoff. You don't want to shut off utilities or allow them to be shut off because while they're in your name and the tenant wasn't paying, you stopped paying those utilities. That's not a good enough reason. It's a bad setup and you shouldn't do that, but you should act faster to deal with the non-payment and not just let the utilities get shut off. That comes with some pretty stiff penalties. No matter really where you are in the country, that's usually a terrible idea. Don't let that happen. So what can you do? Well, you can go to your lease and utilize it, particularly if you have an application of funds clause. If you can simply apply funds that are paid, for example, the following month for rent and say, because of my application of funds clause, I can clear out the utilities. That's the first one I'm going to clear out because you didn't pay them last month. So now you continue to owe money for rent because the utilities got cleared out first. That's the oldest debt from last month. Whoop. That's gone now, thank God, because, man, that was looking pretty bad. But you paid them, and great. But now here's a notice of default because you haven't finished paying all of your rent. Now, they're going to make the claim, no. I made a payment toward rent. I even put it on my check, it was rent, or on my money order, or in the tenant portal. I said this should be applied only to rent. Well, your application of funds clause should address that very thing and say, it doesn't matter what you say, you agree that every payment I receive can be applied first to non-rent obligations. And so your application of funds clause can be used in this way to fund old utilities. Don't carry that debt over and over, month after month after month. If you have an application of funds clause, apply the funds first to the utilities. If they have a rent balance, issue notice. And notice is going to be key. Issue notice, number one, when they haven't paid the utilities in accordance with the lease terms. If the lease says you issue a bill in accordance with the billing procedures that are in your lease, and the matter is, or the amounts are due immediately, or they're due within 5 days, or whatever your lease says, and they violate the lease in that way, you're issuing a notice. So by issuing notice of non-payment of the utilities, and then once the utilities are paid from the subsequent monthly rent payment, you're issuing a notice for non-payment of rent because it's deficient because they had a debt from last month. You can demonstrate to the court, look, I was on my game. They had a lease, they had an agreement, the agreement is clear, and every time they defaulted, I issued notice, because ultimately you might have to evict. But if you're not papering this issue with adequate notice and you're not applying funds in this way, you're going to be left out in the cold. And I've seen it happen, where you're going to have a $500, $600, $700, $800 utility bill that, in your opinion, never got paid. In my opinion, got paid. You just didn't credit it properly using your application of funds clause. So if you've got a good lease and you've got a good clause that allows you to apply funds this way, utilize it and issue notice and get rid of a tenant that's just going to be trouble month after month after month. Don't tolerate this. Use your application of funds clause in this way and you're going to be much better off. And then again, and this is just kind of the default. If they're constantly in default and constantly avoiding the payment of utilities, this is somebody you got to issue notice of default to, and you got to evict. So I hope it's clear that things that you can do to prevent this. Number one, don't keep the utilities in your name. That should go without saying. Number two, if you can transfer and they get the utilities in their name and you can shut everything off, make sure that happens before they get possession, before the keys are ever handed over to your tenant. And then number three, don't go do something cavalier by assuming they know what the rules are. Make it very clear. Always clearly stated utility rules in your lease. If you do have to keep them in your name and they are billed, say on the 20th of the month or whenever, and they pay a portion of a single meter, it's very clear how that's portioned out because your lease says it explicitly. Don't take things into your own hands and shut utilities off or allow them to be shut off when the utility is in your name simply because they're not paying. That's probably illegal no matter where you are in the country. And finally, if you have an application of funds clause, use it. So those are my pointers for utilities whenever they are in your name. Again, it's one of those things that's going to trip up landlords. Unfortunately, it's a real thing, and we just have to deal with that. So if you know the best strategies for dealing with it, it's going to result in fewer problems. But you have to presume from the beginning that there will be a problem. And if you don't have a strategy in place for dealing with it, It's going to cost you a lot of money, and renting to tenants is not going to be as profitable. So my previous tenant, here we go. We got a question here. My previous tenant might not pay the utilities bills after leaving. Is there any accountability that comes on an owner in case he defaults and never pays in the future? Well, again, if you've got an application of funds clause and you can remove that from subsequent payments of rent, that's good. If we're talking about the end of the lease and you haven't utilized that application of funds clause, well, you should still have a security deposit in place. And if you're telling me, Ernie, that security deposit got used months ago, well, that's a problem. I wouldn't use security deposit funds to cover things until the end, and I wouldn't leave things until the end for dealing with. Utilize that application of funds clause during the lease term, because nothing is a stronger argument for you than pay up or hit the road. If I have to, I'm going to apply your funds in accordance with the lease, oldest debt first. And if I have to, I'm going to issue notices. And if you don't clean up your act, I'm going to issue a notice to vacate. And if you don't leave, I'm going to evict you. By dealing with these problems earlier in the process and issuing good notice so that you can establish with the court what you've done, you're going to be a lot better off. Here we go. We got a late hello, Ernie. Hello. Glad to see you. What do you think of RUBS for shared utilities? I don't know what a RUB is. So Scott, if you'll define that acronym for me, what do you think of RUBS for shared utilities? Not familiar with that. And if I have heard it, I simply don't remember what that stands for. RUBS for shared utilities. Let me know. I'll be happy to let you know what I think. But for now, we're going to go on to the questions. Again, if you've got a question, you're welcome to add that to the chat. I'll be glad to answer that question for you. But if you are not part of our mailing list, which I encourage you to be part of our mailing list, if you're not part of our mailing list, then the ticker along the bottom shows our email address and our phone number. You can give us a call, send us a text to get on that mailing list, or you can email me at info@attorneyeg.com, and we'll add you to that list. Otherwise, if you're a member of our Facebook group, you'll get announcements of these live events, and you can ask your question ahead of time, and we'll be happy to prepare an answer for you. All right, so here we go. We got the acronym Ratio Utility Billing System. And so I'm assuming this is something that is set up in the lease. I myself am not familiar with this. Is this something that's done automatically through the utility company? I got to tell you, I just don't have experience with this and how that's figured out. But if there's some kind of system that's set up to determine the usage of a particular tenant, and by ratio, I imagine you're talking about a proportionate share of a unit based on maybe the unit size. Sometimes apartment complexes do this to figure out, based on square footage, how much of the utility bill gets attributed to a particular unit. But that's part of the lease. If it's understood that you're going to pay a particular percentage based on your unit size, then yeah, that system is probably what you're referring to. I'm not super clear on that. But that would be the way that you can establish it. It's in the lease. It says you, for example, are sharing a meter with other tenants. Your portion represents 18% of that shared usage, and you agree to pay 18% of the monthly billing, and you're told on, say, the 20th of the month, and your payment is due, within 5 days or within 3 days of that billing statement being delivered to you. So what about a relative of a previous paying tenant who stopped paying rent in full and left without notice, and we only had a verbal agreement? Well, if you only ever had a verbal agreement, it's hard to enforce it because there's really only two promises in a verbal agreement: the amount of rent and the location of the rental unit. That's basically it. So who pays? I guess, that's up for debate because you don't have anything in writing. So it's likely the occupant who is going to pay. But you've got a fact issue. Who did you make your agreement with? Who agreed to pay what? Unfortunately, that muddies the water. He left me stuck with his squatting niece who isn't paying. Well, the squatting niece is probably there because the other tenant who you did permit to be there allowed her in. Did you ever limit him to the number of guests he could have or the number of occupants that could be there? Unfortunately, that's one of the problems with an entirely oral agreement. You don't have any prohibitions of nieces moving in, and then so who do you evict? Or who do you mention? Does the niece owe you this money if you never entered into an agreement with the niece? Probably not. You might have to name the uncle in your lawsuit because he's the one who agreed to pay you rent. And he apparently is the one who let the niece stay there. So he's probably the only person that you can mention in your lawsuit. Again, assuming the fact is you had no agreement directly with the niece and you only ever entered into an agreement with the uncle. So that's how I would resolve that. I've already provided a comprehensive non-renewal notice through multiple channels. Am I also legally obligated to send a separate notice to vacate to ensure she vacates the property promptly? Well, understand that a notice of non-renewal is not a notice of default. It simply says, I don't intend to continue this lease beyond date X. You are on notice that the lease will not automatically renew. And as long as you gave a proper notice of that, you're really just saying the lease ends here without actually saying that they are in some kind of default. A notice of termination, a notice of non-renewal, these are not notices of default. You don't have to do anything wrong for the lease to come to an end. The notice to vacate comes in if there's a default. And that might occur because the notice of termination says you got to be out by this date, and they're there one extra day. Now they're in violation of that notice of termination. And so a notice to vacate would be appropriate because they're guilty of holdover. They might also be guilty of non-payment of rent because presumably that notice of termination or notice of non-renewal ends at the end of the rental period that was otherwise prepaid. So typically that happens at the end of the month. And if they stay into a new month, a new debt obligation arises. But more importantly, there's holdover. And so that's when you would issue a notice to vacate and say, look, you're not supposed to be here. Your rental agreement ended the day before. Now you must vacate or I will evict you. Now, are you still entitled to rent? Absolutely, and probably under the previous rent terms. But if you accept rent, what happens to holdover? Well, I would argue that the holdover is evaporated at that point, and you've got a different issue. Now you've got a month-to-month tenancy based on your acceptance of the rent. Typically, I advise landlords to reject rent at that point and say, no, you got to go. But when you sue, say, and on top of the holdover, you also owe me for the rent value for however number of days you're actually on the premises beyond the date of non-renewal or the date of termination. So again, reject the rent from them during the eviction process, but request the rent from them through the eviction. That's pretty much the way it works and the way that I advise clients. Yes. How can I get rid of her? You're talking about the niece that the uncle left behind. You can name her in the lawsuit, but again, your agreement is probably with the uncle. So I would name him as well. Let the court parse out who is ultimately to blame, but I would name him if he's the only one you entered into an agreement with, but you're probably going to have to send notice to both of them that they both need to vacate and then sue both of them because one or the other, probably the uncle more than the niece, is on the hook because of your original agreement. Again, this is the problem with oral agreements. It's unclear who promised what to whom. And so to cover your bases, name them both in the eviction. And the court may say, look, we're not going to take a judgment against the niece. She never entered into an agreement with you, but we will take a judgment against the uncle. And the writ of possession that might issue from that should apply to everybody, right? So not just the named party, but all occupants. And that's typically how that works. She won't answer the door. She changed the lock, so I can't get my property. She won't answer texts or calls. I can't afford to pay court fees or power in my name. Well, that's the risk that we run when we turn into landlords, whether we mean to or not. Unfortunately, there's no way for you to otherwise get in, especially without a written agreement. If you permitted somebody to enter, the only way to recover possession is through the courts. And yeah, it's a tough spot, but he moved out of state and won't talk to me or answer my calls. Again, your only option is to file suit. If you're in the Houston area, I know a lawsuit like that costs $145. If you file it yourself, you might have to pay an extra $85 for service against a second occupant, but this does not sound like a good situation. You're going to have to find the money, file the lawsuit, send the notices first, and then file the lawsuit. Otherwise, you're going to be out in the cold, literally. Yeah, and that's not a good spot to be in. So, all right, so we're going to go ahead and get into the questions again that were shared with me ahead of time. I've got a number of questions that I want to discuss. If you continue to have questions, those of you who are here watching live, go ahead and add those questions to the chat, and I will get an answer to you in just a bit. But for now, let's start off with question number one. This is Catherine Workman. Catherine, if you're here, here is your question, and I will get to it. Does it really matter whether you go to the Justice of the Peace or to the county court when it comes to actually getting the payout if you are suing for damages and unpaid bills? I know with previous judgments, right here. I know with previous judgments with the Justice of the Peace, we've never seen a dime. Is it better to go with the county court, or if you want to actually receive the payments? The particular lawsuit is over $20,000, but most of them are not. So the issue to go after your tenant, once you've recovered possession, you've got damages, and you've got a lawful claim for some kind of lawsuit. And I tell this to all of my clients, and sometimes it even means I don't get business from this because I dissuade them from filing a lawsuit, because I ask two very important questions. Number one, can you find them? Do you know where they are located? That is, do you know where they live, or do you know where they work? Because if you can't serve the lawsuit on the tenant, you can't get a judgment. You have to be able to personally serve them, not you, but somebody. You have to be able to find them, not you, but somebody, either a process server or a constable. If you don't know where they are, they're not going to know where to go. And no, they're not going to go through the trouble of tracking them down for you. You need to disclose to the court where the person can be found. Usually, if you know where they live or you know where they work, those are the easiest two places. Okay. So do you know where they are so they can be served? Second question is, if you can find them, do you know whether they have the assets to pay your judgment? In your case, you've got something over $20,000. Let's say you hire counsel and your final judgment is $30,000. You got a $30,000 judgment. But if the people that you sue don't have $20 to their name, I mean, you've got a pretty expensive piece of paper. You got a $30,000, debt that you can collect, but what did it cost you to get it? I mean, if you paid an attorney $10,000 to get a $30,000 debt, in a nice, good-looking piece of paper, but you can't collect it, is it even worth going through? I would say it's probably not, and I don't tend to encourage clients to go after tenants who don't have the capacity to pay. So it's not a matter of the court necessarily. It comes entirely down to the ability of the tenant to pay. Can they pay it? Great. If they can't, then I don't know that it's worth it. But let's say instead you've got 5 judgments out of the justice court and you got 1 judgment out of the county court. Again, it doesn't matter where the judgments are. What matters is the ability to pay. And let's say that in fact your tenant or the person you sued does have, in fact, all 6 of them have the capacity to pay. How do you collect? Now, again, if you're from around the country, this might not apply. But in the state of Texas, and in most states, there's a procedure similar to this. But I'm going to talk about a Texas-specific procedure. You can abstract that judgment. By abstracting the judgment, you can identify some personal information about the defendant. Maybe the last 3 numbers of their social, the last 3 numbers of their driver's license, and their date of birth. All information you may have acquired during the application process. And if you can attach this to the abstract of judgment, you create what's called a judgment lien. And so maybe they have accounts, maybe they have property, or maybe 5 or 6 or 7 years down the line, they're looking to buy a house. And they're at title trying to secure everything they need in order to buy a house. And the title company finds, whoop, there's a judgment lien for $7,000 from 2026. And now time has passed and additional interest has accrued on that judgment, and they want to buy a house. And their lender tells them, look, we don't need any kind of issues that might affect our collateral. Before we extend this loan to you, you need to clear that judgment debt. I get calls like this all the time from parties who are looking to clear off debts from old evictions that we abstract. We don't do 100% of them because our clients don't always ask for it. But if you ask for it and create a judgment lien, it could be that years down the line, a tenant who wants to buy a house now has to clear this old debt. I get a call, a check comes to me, I release the abstract of judgment, and they can go buy their house. But now my client has received their full judgment plus interest because they recorded a judgment lien. So if you're recording a judgment lien, you're likelier to collect from someone who maybe doesn't presently have the capacity to pay, but down the line does. Only you can, inform your attorney of that. Does it exist? Is it likely that you'll be able to collect? Then maybe it makes sense to file that judgment, record it with the identifying information from your tenant, and then wait and see if maybe sometime down the line you get that always celebratory phone call that funds are on their way. So that's what I would say in that situation. Mr. Escamilla, Homero Escamilla writes, what can I do with a tenant that always pays partial payment and late from the first payment, but does pay at her own terms? This is easy, Homero. You issue notice. And you charge late fees. If you're waiving the late fees and they do this every time, you're essentially telling the tenant, you can pay whenever you want. And if you're not issuing notice, you're condoning bad behavior. This is not something that I recommend. So always, always, always issue notice for late payment. And if you've got late payment where you can charge late fees, 100% of the time, you are collecting those late fees. But Ernie, she only ever pays the rent and never pays the late payment. Well, do you have an application of funds clause? Because if you do, the very next month when she submits payment, even a partial payment for rent, apply first the payment to the full amount of the late fee. Anything that's left, that goes to rent. And then you're immediately issuing a notice of default for partial payment because your lease should be clear and probably says something to the following effects. Your rent is due on or before the first day of each month. And if they haven't paid the full amount of rent, particularly because some of it went to last month's fees, you're issuing a notice and saying, you have failed to pay rent. You might even be issuing a notice to pay rent or vacate, so that if in 3 days they haven't paid the full amount of rent or vacated, on day 4, you're filing that eviction. And the reason you're doing this isn't because you're a mean guy, it's because you're enforcing the terms of the lease. that might get them to pay the full amount within 3 days. But if, again, they only issue the rent amount and they don't pay you late fees, guess what they continue to owe? The late fees. So next month, you're going to do it again and again and again. Eventually, they're going to be in a position where they've paid so many times late and you've issued so many notices about this that you're going to be able to evict them for non-payment or for continued violation of the lease. That's how you deal with it. You don't allow it to happen without issuing notice, and you don't waive late fees because that's only going to encourage future bad behavior. All right, so I property managed where the owner lived in a back house and tried to split utility bills manually. The landlord-tenant relationship became volatile. Avoid this. It's better to include them in the base rent. Yeah, I mean, if it has to be that way, unfortunately, in this situation, it kind of sounds like if the landlord lived in the back house, the size of that house probably proportionally was significantly less than the main house. And so in that case, you're probably talking about a ratio. And so if that represents 20% of the property and they represent in the rent house 80% of the property, that's how things should be done. If that landlord was trying to scam his tenants by saying, something less than 20%, I just don't see how that's going to work. Or trying to say, hey, you pay 100% of the utilities. I just don't see how that's going to work. And if your lease is clear, it's easier to enforce. If your lease is unclear or silent, which is actually worse, you're going to run into a problem just like this. You might just say, look, we're going to just roll it into the rent cost, or bite the bullet and get a second meter. If you're going to live there and this issue is going to be present every time you have a tenant, talk to the utility company, get a second meter. That way you might decide in the future to find your own place and rent that place out, and you can avoid the problem entirely. 2 separate meters for 2 separate units, easy peasy, lemon squeezy. That's what I recommend. Gotcha. Tenant hasn't paid March's rent either. After sending the non-renewal notice, I mean, as of about March 3rd, you had basis for notice to pay rent or vacate. Now, can I send her a 3-day notice to vacate and initiate the eviction process? Well, that depends. Did you send her a notice of rent delinquency in the month of March? If you didn't, and you're in Texas, the rules are different now. They changed on January 1st, 2026. And so what I'm recommending to landlords, certainly if you did not send a prior notice, you got to send a notice to pay rent or vacate in the month of April. So if rent's due today, they haven't paid, then as early as tomorrow, you can send a notice to pay rent or vacate. And that can be a 3-day notice. But if they pay the full rent, they get to stay. I don't think they're going to pay anything. So if they didn't pay March and they now also owe April, and you send that notice tomorrow, are they going to have a double rent payment in the next 3 days? Probably not. They might just pack up and go, which is what you want anyway. And so whether they leave or whether they dig their heels in and say, I ain't leaving and I ain't paying, you send that notice to pay rent or vacate. And if they don't do one or the other, then yeah, go to the courthouse, file the eviction. But you got to send notice, and you got to stick to what the lease requires. Again, the fact that you sent a non-renewal, but they were otherwise in breach for non-payment of rent in the month of March, I would have proceeded with a notice to pay rent or vacate a few weeks ago, but you can't undo it now. So proceed, please, with that notice tomorrow to get rid of them. That's a bad tenant. How do you fight a non-renewal challenge in Texas? I don't exactly know what you mean there, Jeff. A non-renewal challenge. So let me guess. It kind of sounds like you, the landlord, are sending a notice of non-renewal, but they're challenging that. I mean, there's no basis to challenge it. Chapter 91 of the Texas Property Code says, as long as you give the requisite notice, and by default it's 30 days, your lease might require a little bit longer, but as long as you give the requisite notice, you're allowed to terminate. And so I don't understand what the challenge would be. I would just cite Chapter 91 of the Texas Property Code. As long as you follow that and you follow your lease, you should be fine. Hello, Belinda. Good to see you. Okay, Jeff's back. Does the judgment lien work across state lines, or only works if they stay in Texas? So the judgment lien that you create applies in the state of Texas. It doesn't automatically jump state lines. And so is there a process to have other states recognize your judgment and then allow you to establish a judgment lien there? Yes. You'd have to consult counsel in each individual state to find out what their procedures are. It's called domestication. So you can domesticate your judgment anywhere else in the 50 states and effectively create a judgment lien. You just got to follow their rules. And I don't know their rules, so you'd have to seek out counsel in each of those states wherever you're looking to go. But yes, it is technically possible to have your debt recognized in another state. If a landlord pays utilities, can the landlord specify or adjust the AC temperature set up by using special thermostats, as some tenants like to leave AC at 62 during the summer, which damages the AC? So one of the points that we talked about in today's lesson is, what does your lease say? Did they agree that you get to regulate the temperature? If they didn't, and your lease is silent as to this, or your house rules are silent as to this, you can't enforce something like this. You can't just say, well, Your Honor, it's common sense, because it is not. If you want to put such a limitation in your lease, you are free to do it, and they're free to say, what? I'm not going to abide by that. I will not agree to this. Great, I'll take that lease back, and I'll find a tenant who will. Thank you very, very much. But if it ain't in the lease, it's not enforceable. So that's the long and short of that. What if the lease says tenant pays utilities, but landlord has been paying the utilities and has texts and emails stating thus? I mean, that's like paying somebody's ice cream bill. I mean, why would you do it if you didn't have to do it? So the lease says the tenant pays utilities, but the landlord has been paying it. Well, I mean, is the landlord gifting these utilities? Probably not. The landlord's probably just doing some bad accounting and just isn't getting around to it. We'll see. Has a landlord de facto accepted responsibility for utilities? Again, I don't know. I need a few more fact details. There is a retaliatory $1,200 bill. Again, I need more facts to know. The lease says the tenant's responsibility. The landlord's been paying it, though, and hasn't really mentioned it. And maybe after $1,200, the landlord suddenly says, oh, crap, here, pay $1,200. Well, number one, how reasonable is that? Number two, how accurate is that? I don't know, and I don't know. But if it's the tenant's debt, then the tenant still owes it. And in some leases, there is a provision that says, look, the fact that I've waived something or haven't enforced something doesn't mean that it doesn't exist. It's called a non-waiver clause. And so can the landlord enforce it? Sure. But how strictly can the landlord enforce it if all of a sudden it's suddenly a $1,200 bill and the rent's only $1,150? Right? That's a big chunk. If the landlord has done poor accounting, I don't know that the court's going to accept it as, you got to pay me in 24 hours. So the landlord has to act diligently and reasonably. But a debt is a debt. And if the tenant owes the debt, the landlord can enforce it. The issue then is, if the landlord did a bad bookkeeping thing, how much time should the tenant be allowed to pay it? It's probably going to come down to some kind of reasonable amount of time. And unfortunately, bad bookkeeping tends to result in loss. That's just the way of it. Great, thanks. Jeff, you are welcome. I hope that helped. Did I miss my question I sent about the ESA issue? Well, I'm not done. Let's see. Well, unfortunately, Belinda, I don't see a question from you. If you didn't make it by the 2 o'clock deadline, then I recommend you add that question to the chat, and I promise you I will get to it. Let's see. La Tremenda, 2000. Hi, Ernie. If an eviction is filed and the tenant decides to appeal in order to buy himself more time, how long does it usually take for the appeal to play out? Well, I'm assuming you're in Texas, because that's all I can really talk about is the state of Texas. State law says, give or take, about 3 weeks. Now, do all courts adhere to this rule? No. Do certain things get in the way? Yes. Sometimes there are emergency motions, or sometimes the tenant asks for a jury trial. That could extend things for months, unfortunately. So by default, it's usually about 30 days, 30 to 45 days. And many times, if they're just trying to buy time, they're going to move out voluntarily before you get to trial. But if you're asking me how long will it take to get to trial, I usually tell clients within about 30 days. State law now says it should be within 21 days. But again, not all courts follow the law to the letter. Landlords need to have various notice forms available to send to tenants. Yes, I agree. Where can I obtain these forms, or do I need to create my own? Well, that depends where you get your lease. So I draft a lease, and I draft these kinds of forms all the time. And so you can get them from an attorney. If you are a member of an organization, maybe you get your lease from the Texas Apartment Association, well, they may have their own forms that you can utilize if you're a member. Maybe you're a member of Texas Realtors or the Texas Association of Realtors. They have a lease, and they have various forms that you as a member might have access to. So it really comes down to where you get your paper from. And so I hope that's helpful. If you're part of an organization or an association, you might already have access to them. So there's that. Otherwise, you either create your own, read the text of the code, or talk to an attorney. And certainly for the state of Texas, I can assist you with that. The tenant owes March and now April and has stopped communicating. He has no intention of paying. He knows we're done. Sounds like you're going to send a notice to pay or vacate. A notice to pay or vacate. Give him 3 days or longer if your lease requires it, but by default in the state of Texas, it's 3 days. Notice to pay or vacate. If he has no intention of paying, then he can vacate. If he has no intention of paying and no intention of vacating, then you will go to the justice court and file your eviction in accordance with state law. Here we go. Belinda's back. Thank you, Ernie, for looking at this later. ESA issue. I had to give you a little information to explain. Okay. And then Tony writes, thank you, Ernie. You the man. I appreciate it. Thank you. All right, here's Belinda. The tenant's lease ends 5/31. She sent me a message on 3/27 letting me know she now has an ESA. Okay. She sent the documentation. I did an online search of the LPC number, and it came back to the person on the letter. I called the LPC to confirm. Good job. Always confirm. The call went to Google, so I did not leave a message. I will call again tomorrow. I encourage you to do that. When I call, I will only be asking if the letter provided to me by one of the tenants was written by them, and if the letter is authentic and currently valid. Once that is determined, I think it is a valid letter. The tenant lives in a dorm room with 3 other tenants. Once everything is verified, I'll be sending a notice out to the other 3 tenants. However, another tenant called me today about renewing her lease and want to know if the ESA tenant is coming back. Okay, so let me address first the confirmation of the authenticity of the ESA letter. Yes, you have the right to call and confirm that medical professional issued that letter. And I don't know what the letter says, but if it identifies an animal, all you're going to confirm is that they issued the letter, that the person in question is their patient, And if it identifies an animal, and that's the animal that the tenant is asking to be recognized as an ESA, then they have met the requirement. They had a licensed medical professional who said that they were under medical care, that they required an emotional support animal, and they identified the animal in that letter. That's usually essentially the bar, not a very high bar, but that's usually the bar to get an ESA approved. The ESA tenant has had someone living in her room, and she does not think that it is fair for her and the other two tenants. This is the default. That's a different matter. I asked her, does the unauthorized person living have access to the external door code? She said yes. She has seen her coming and going without the tenant there. She also uses the kitchen and washer dryer. How do I handle this? Well, that sounds like a simple notice of default. Personally, I would recommend that you send a notice of default and say you have an unauthorized occupant. You have 2 days or 3 days to remove the unauthorized occupant. If they continue to reside there, I may have to issue a notice to vacate for violation of the lease. And then I would follow up. Is that unauthorized occupant still there? I might give another notice and another notice. I wouldn't mention the ESA at all because you don't want them to say, I'm being retaliated against because I have an emotional support animal. Again, the default for the unauthorized occupant doesn't allow, again, the fact that they have an ESA doesn't allow them to violate the lease. So that's not going to be a good enough excuse, but you got to be on it issuing notice. And I preach a 3 strikes and you're out rule. So if you say, hey, look, I notified you about that unauthorized occupant, and then I did it again, and then I did it again, you still haven't done anything, here's your notice to vacate. So that's my recommendation. Confirm the ESA. If you cannot, or if it turns out that that licensed medical professional says, I didn't issue that letter, then boom, that's another strike. So again, if you're building non-rent violations against the tenants, 3 strikes and they're out. I think that's good evidence that you can use. The tenant will need to sign a release of information for the therapist to verify they wrote the letter. Maybe the letter itself is that release because they disclosed it to you. I don't think they need to sign anything because, again, you're not basing the call on hearsay. You're not basing it on a guess. You've got the letter. And so if they gave you the letter voluntarily, then you can call to confirm. I don't think you need anything else in writing. It's not a violation of HIPAA because they disclosed it. And they're not necessarily disclosing their medical issue. They're disclosing the role that an animal plays for their medical needs. And so there's a slight difference. In terms of accommodation, it's reasonable because, again, without having to disclose the basis of the emotional need, they're simply disclosing the fact of the emotional support animal, which is already readily obvious unless it's a pet. So that's how you get around those HIPAA issues. I am a therapist and can confirm this. Well, again, I don't know that as a therapist that necessarily affects what the Fair Housing Act requires or what state law requires for information that is readily disclosed to a landlord. While generally speaking, a tenant does have privacy and the right to privacy to their medical information, once they request this specific accommodation, they have to provide some documentation that supports the fact of their medical need and the fact that the animal in question satisfies that need. That's part of this very low bar for them to be allowed to have this. Otherwise, if a landlord couldn't confirm this, they wouldn't be allowed to have an animal when they are otherwise restricted from having pets. So state law does allow this inquiry once a letter or some medical documentation is voluntarily presented by a person requesting this accommodation. So that's my legal analysis of this issue. Let's go on. Okay, Brian Croissant. I think landlords for tax benefits and liability mitigation should place their properties in some form of revocable trust. I want to continue claiming depreciation as a real estate agent on my taxes that I want to ensure when they are passed down to our children, the children continue to get a step-up basis for their taxes and that it mitigate liability as best as possible. I hear the LLC argument all the time, but it usually stops you from claiming the property's depreciation on your taxes. It makes insuring the property more difficult and more expensive. It stops personal umbrella policies from covering and carrying over on liability. You need a commercial umbrella. I use an LLC not to commingle monies and manage the lease. I use contracts between myself, the landlord, and the LLC, stating the LLC's obligations and debt repayment to me. I keep the loans in my name as well. Easier to qualify for, easier to refinance. What is better in your opinion, LLC or revocable trust? Well, that's a lot of information for what seems to be a pretty simple question. And the truth of the matter is, it's going to come down to how you use both. You yourself cite benefits and risks, liability, and other issues that come up. I'm not a tax attorney, nor am I a CPA, so I don't answer questions because I'm not qualified to do it pertaining to depreciation or other tax matters. As far as I'm concerned, they're both equal in terms of liability protection because it shields you, the landlord or the individual, from personal liability for any of the acts of these entities, the revocable trust or the LLC. For purposes of legal liability, either, in my book, will be equal. For purposes of taxes and depreciation and other matters, insurance, that's going to require another expert. So talk to your insurance provider, talk to your CPA or your tax preparer, talk to a business law attorney regarding formations. Those are not expertises that I have, and so I don't comment on those matters. As it applies to your role as a landlord, I'm going to advise you that separation from your individual role and your individual assets is always a good idea. Don't be connected to your property as best you can. Keep your property at arm's length. And whether that means a trust, whether that means an LLC, whether that means some other means of separation, do that because that's always better for you. So, Brian, I know I didn't get deep into all parts of LLC versus revocable trust, but mostly it's because I just don't do either. I'm not a business attorney, and I'm not a tax attorney, and I'm not going to pretend that I can answer on those bases. So that's that. And here is our last question from Heather D. Heather writes, my tenants have a long-term lease and have not violated it. That's good. Long-term tenants are good, especially if they don't violate. Tenants have invested their own funds in the property upkeep and in pleasing my neighbors. That's not as good. I don't know what you mean by have invested their own funds, but that makes me a little queasy. Let's go on. Neighbors are now threatening to sue me, saying my tenants have ruined the enjoyment of their home. The tenants have begun legal proceedings against the neighbor for harassment. I've agreed to sell my tenants the home, and they have come up with a large down payment very quickly. 3 of the neighbors have expressed they wanted to buy the house if I was selling. One of the interested parties is the threatening party. If the tenants did their own research with the city and have evidence of collusion and other issues by the neighbors and the small city, how can I support the tenants without opening myself up to a lawsuit? Well, there are a lot of facts here, including this issue of collusion with a small city that I'm just not aware of. I also don't know what you mean by they've invested their own funds in the property upkeep, because I typically don't advise landlords to allow tenants to make any kinds of improvements on the property. That usually results in its own problem. But it sounds like the rules of the game have changed, because you said the tenants have begun legal proceedings against the neighbor. I've agreed to sell my tenants the home, and they've come up with a large down payment very quickly. If you have sold the home, I don't see how you're involved in this at all anymore. If you've sold the home and you've entered into an agreement for the sale of the property, you're out. Presumably, the tenant is no longer the tenant. They are now the new homeowner, and you're the former homeowner. So I'm confused how you're still involved in any way. The fact that you've agreed to sell your property to them and they've paid you a down payment means you're locked in. Even if it's an owner financing agreement, your former tenant is now the owner, and they've got a significant ownership interest. And it doesn't matter that other parties have offered to buy the home. They can't if you've already sold it to your tenant. Your liability ended the moment that you sold the property and the tenant became the owner. So either I don't have enough facts here to properly advise you, or you didn't actually sell. Because again, even if you sold this through some kind of owner financing and you retain some kind of a lien on the property, again, if you're no longer the owner, you no longer have liability. Part of ownership includes assuming all liability, and so it doesn't sound like you're in much trouble, unless, of course, you signed an incomplete purchase or nothing was signed. And that's always a bad idea. And so I certainly don't ever try to recommend transacting without something in writing, because in Texas, you can't sell property without a written agreement. And if you've got a written agreement that doesn't clearly transfer title and shift all liability over to the buyer, it sounds messy, and I can't give you a good answer because it sounds like I don't know all of the facts. So if you maybe want to book a consultation or something where I can review documents and I can hear more facts, and give you a better answer. But as of right now, it sounds a little complicated. So that's it. That was the last question. We're just over an hour now. I want to thank all of you who joined and all of you who contributed and gave questions. As for next week, April 8th, we'll be back. I'd like to change in my lease. I think I meant to write, I'd like to make a change in my lease, but we're in the middle of the term. Can that happen? Absolutely it can. But there are some issues. And so next week, I'm going to talk about making changes in the middle of the lease term. Can it happen? Yes. Is it easy to do it? Depends. Some changes are very simple and can happen, but there's rules that you're going to want to follow. And so I hope to see you next week when I talk about changes to a lease in the middle of the lease term. It is possible, but you got to be careful if you want to get it done correctly. So again, I want to thank all of you who stuck around all the way to the very end. I appreciate you coming out. I appreciate all the questions that we got from you guys throughout it. Here we go. Thanks, sir. You're very welcome. Joy, you're welcome. Musicians Matter 190. Belinda, as always, you are very welcome. Thank you, Ernie, for great answers. Another informative session. Chan, I appreciate you. And thank you for your time. Kendralee Martin, you are very welcome. And I appreciate all of you who joined us today. As always, I look forward to seeing you again next week. Landlords, happy leasing. Appreciate you. Oh, we got something in late. This is a fun call. I'm glad I joined. Don't mean fun because the topics are quite serious, but certainly educational and insightful for landlords at various stages of their landlordship. Awesome session. Hey guys, appreciate you. And as always, happy leasing. Have a good one. Oh, happy Easter.